I'm Drew Stevenson. This is for my administrative law class. We're going to be talking about the case Automotive Parts and Accessories Association versus Boyd. This is a 1968 case from the DC Circuit Court of Appeals about substantive review and the rulemaking process for agencies. So let's dive in. This case was a challenge to Motor Vehicle Safety Standard number 202, which basically required factory installed front seat head restraints in all new passenger cars. In common parlance, some people call these headrests, but it's really not to help you take a nap while you're driving. This is to protect you from breaking your neck from whiplash if you get in a collision. Basically, the force of the collision forces people's heads forward and then back kind of violently and can cause a broken neck or permanent neck injuries. The petitioners here who don't want this rule actually made the head restraints or headrests, but these were made to be accessories that you added to your car after you purchased it, if you went to a body shop or something like that. And so they sold these as an aftermarket product, and if they came standard on all new cars, then they wouldn't be able to sell them because everybody would already have them on their car. This case is a kind of famous example of early judicial review under the Motor Vehicle Safety Act. It's also kind of a key case on agency rulemaking procedures and judicial review under the Administrative Procedure Act, or APA. Our central legal issue here is whether the statute required the agency to use formal rulemaking procedures under APA sections 554, 556, and 557, or if informal procedures under section 553 were fine. The agency had followed informal rulemaking procedures under 553, and the plaintiffs who didn't like the rule were challenging it on procedural grounds, although in fact they just didn't like the rule. They didn't want the rule itself, but their hook in litigation was to say that the agency should have followed formal rulemaking, and therefore the rule that they came out with is invalid. So I just want you to be clear on the difference between formal rulemaking and informal rulemaking. Formal rulemaking is triggered by statutory language or requirements in the enabling statute, something like on the record after an opportunity for an agency hearing. And it involves trial-like proceedings and hearings, sworn testimony, the opportunity for cross-examination, formal findings of fact based on a hearing record. And in practice, this often ends up taking several years. It's very time-consuming and costly for the agency. Informal rulemaking, or what we call informal rulemaking under the APA, is better probably known as notice and comment rulemaking. And so this involves the agency publishing a notice of a proposed rule, allowing a period for written comments to be submitted by anyone in the public. They consider the comments, and then they issue a final rule that contains a concise general statement of the basis and purpose for the rule. And this does not require a trial-like hearing. It takes a lot less time. It's basically decided kind of on the paper submissions, and this is all done under APA Section 553. So the problem here is that the enabling statute is a little ambiguous about what the agency was supposed to do when they promulgated a safety standard for cars. The Motor Vehicle Safety Act said that the APA applied, so it incorporated the Administrative Procedure Act by reference, but then it had some ambiguous statements. The court calls it somewhat Delphic pronouncements about what the agency should do and whether they were supposed to consider the record or hold formal rulemaking proceedings. So what the court did, because the statute was arguably ambiguous, is they looked to the legislative history for guidance. The Senate version of the bill, now remember, when bills go through Congress, usually separate bills go through the House and the Senate. They're similar, but they have little differences. And then if it passes, if each one passes each House, they go to a conference committee that basically reconciles the two versions, which go back to each house for sort of a final thumbs up or thumbs down, and usually they're approved. So the Senate version of the bill, when it was first going through Congress, had expressly excluded rulemaking requirements under 556 and 557. In other words, it was very clear in the Senate that the Senate did not intend for the agency to use formal rulemaking. But the House bill, actually, the language became the final version and it was less clear. So even though the House version's language made it into the final rule, the court looked at the conference committee's report, and the conference committee had an assumption in the legislative history that had been explained by one of the senators, Senator Magnuson, that the secretary would utilize informal rulemaking procedures of APA Section 553 and would use formal rulemaking only if he determined that it would be desirable or appropriate. In other words, the court concluded that the legislative history suggested that the agency was free to choose and that informal rulemaking was certainly permissible. In addition to looking at the legislative history, the court looked at other parts of the statute. This is pretty typical in statutory interpretation cases. So they look at the statute's overall structure for guidance. And there were other parts of the same act that supported informal rulemaking. In other words, it authorized informal consultations with various parties or stakeholders, research, experimentation, and so forth that all are a little more consistent with 553 procedures. So the court took that and then kind of went a step further and said that the task of setting safety standards, in the court's view, is really inherently legislative. It involves basic policy determinations and making difficult decisions about trade-offs, and rather than resolving factual disputes between parties. And so informal procedures are perfectly appropriate for setting safety standards. The association that made these head restraints had argued that there were judicial review provisions of the Motor Vehicle Safety Act that they thought implied a formal on-the-record hearing. The language was a record of the proceedings had to be kept, and they thought that that implied an on-the-record hearing. But the court here says that's not right. There's just different types of records, formal rulemaking and informal rulemaking, and that informal or notice and comment rulemaking also has a record that includes all of the procedural steps that the agency went into, the meetings they had, the basis that they had, their consideration of other alternatives and so forth, the submissions and public comments that they get during the public comment period, and so on. So therefore, notice and comment rulemaking or informal rulemaking is permissible. Remember that APA Section 553C requires agencies to incorporate some kind of concise general statement of basis and purpose when they do notice and comment rulemaking in the final rule that they publish in the Federal Register. This helps inform the public and also enables judicial review or facilitates judicial review by showing the major issues that the agency considered and the agency's rationale and what they thought their legal basis or statutory mandate was. And the court in this case found that those statements were sufficient, that they met the requirements of the APA. Now, when it comes to the substance of the rule, the court was also reviewing that, whether the challenge was also that this was a stupid rule, according to the plaintiffs, or a bad policy. So what the court did was they applied arbitrary and capricious standard of review under 706 2A. And this means determining whether the agency decision was based on relevant factors and was not a clear error of judgment, and whether it was formulated to negate the dangers of arbitrariness and irrationality. In other words, did the agency just flip a coin or pull something out of thin air one day when they wake up and they feel like making a certain rule? Or is there some evidence that the agency engaged in a lot of deliberation and really considered what the best rule would be, went through a process of crafting or formulating the best possible rule, considering all the competing policy considerations. And that's what they had done here. There's an interesting issue in this case about standards of review. We get to standards of review a little bit later in my course. I have some other videos about it. But there's somewhat different standards of review for informal rulemaking and formal rulemaking when we get into the courts. And by standard of review, we mean what does the court do? What type of analysis do they provide when they're deciding the legitimacy of the agency's actions? And so review under the arbitrary and capricious standard for informal rulemaking, the court here says is just as strict as the substantial evidence test or reviewing the findings in formal proceedings. So remember that if we're using formal rulemaking, we might have a different standard of review when we get to court. Well, the court says that informal rulemaking doesn't give you a lower standard or an easier standard for the agency to make. Both are going to involve some searching analysis by the court. And so with notice and comment rulemaking or informal rulemaking, the court reviews the record that's generated in the proceedings. And again, that's going to be the comments that are submitted, the basis statement, what the agency said they did, and the alternatives that they considered and rejected, and so forth, rather than formal findings and conclusions like they would be doing if the agency had undertaken formal rulemaking. I do want you to understand the competing policy arguments behind having these head restraints on the cars. The petitioners claimed that factory installation would make the cars more expensive. So they came into court and they had some arguments about why these were a bad idea and it was a bad rule. They said, look, it's going to make the cars more expensive if every new car has to have these. Now, remember, the people challenging this are the people that install these after you purchase your car as an accessory at a body shop, but they said it would make new cars unaffordable for consumers. It would lead to market consolidation or increased monopolization of the car industry. It would cause all sorts of delays in production if they just came standard with every car. And the agency said, of course, there might be some incremental or marginal increase in the price of cars if cars now come with an additional feature or an additional part that's required. But the agency said this was the only way to guarantee that all the cars had the restraints, and it's really important for public safety because people, when they got in even pretty minor collisions, were suffering really serious and sometimes fatal neck injuries from the whiplash. And they said that performance depends on the head restraint seat structure relationship. In other words, if we could put them in the factory, you had a head restraint that was made for that seat and would fit with that seat properly. And some of the aftermarket ones, you could end up with the wrong size or shape of a head restraint that had kind of been jerry-rigged onto the car seat in a body shop. The court agreed that the public safety interest in requiring a vehicle performance standard for factory installation far outweighed the possible economic disadvantage to the petitioners. And the court found that the agency's reasons were convincing and supported by technical information and the record of the proceedings. And it would be easier to have enforcement and better design, they said, if it was all just done in the factory. I like this part of this case because it helps students kind of get a window into the types of difficult decisions and trade-offs that agencies have to think about when they make safety regulations. So to kind of wrap it up, for key takeaways from this case, the case highlights the difference between informal rulemaking and formal rulemaking, and especially the different types of record that you get of the proceedings in each. So with notice and comment rulemaking, we're going to have the comments that are submitted and the final basis and purpose that's in the final rule. The formal rulemaking is going to have detailed findings that are based on trial-like proceedings and submission of exhibits and sworn testimony and cross-examination and so forth. Also, the case provides some guidance on balancing procedural requirements for reasoned decision-making with administrative efficiency. And that concludes our discussion of Automotive Parts and Accessories Association v. Boyd. Thank you for watching.